This is part 55 as far as our series of lectures is concerned. And in this part, we intend to discuss Chapter 7A of the Criminal Procedure Code, which deals with reciprocal arrangements for assistance in certain matters and for procedure for attachment and forfeiture of property, for which we shall be dealing right from section 105 capital A to 105 capital L. Section 105A starts with the definition, and it says, in this chapter, unless the context otherwise requires, small a, contracting state means any country or place outside India in respect of which arrangements have been made by the central government with the government of such country through a treaty or otherwise. Small b defines identifying, and it says identifying includes establishment of a proof that the property was derived from or used in the commission of an offense. Small c, proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity, including crime involving currency transfers or the value of any such property. Small d, property means property and assets of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and deeds and instruments evidencing title to or interest in such property or assets derived or used in the commission of an offense, and includes property obtained through proceeds of crime. Small e deals with tracing, and says tracing means determining the nature, source, disposition, movement, title or ownership of property. Section 105 capital B deals with assistance in securing transfer of persons, and it says where a court in India in relation to a criminal matter desires that a warrant for arrest of any person to attend or to produce a document or other thing issued by it shall be executed in any place in contracting state, it shall send such warrant in duplicate in such form to such court, judge or magistrate through such authority as the central government may by notification specify in this behalf, and that court, judge or magistrate as the case may be shall cause the same to be executed. Subclause 2 mentions, notwithstanding anything contained in this code, if in the course of an investigation or any inquiry into an offense, an application is made by the investigating officer or any officer superior in rank to the investigating officer, that the attendance of a person who is in any place in a contracting state is required in connection with such investigation or inquiry, and the court is satisfied that such attendance is so required, it shall issue a summons or warrant in duplicate against the same said person to such court, judge or magistrate in such form as the central government may by notification specify in this behalf or cause the same to be served or executed. Subclause 3 says, where a court in India in relation to a criminal matter has received a warrant for arrest of any person requiring him to attend and produce a document or other thing in that court or before any other investigating agency issued by a court, judge or magistrate in contracting state, the same shall be executed as if it is the warrant received by it from another court in India for execution within its local limits. Subclause 4, where a person transferred to a contracting state pursuant to subsection 3 is a prisoner in India, the court in India or the central government may impose such conditions as that court or government deems fit. Subclause 5 says, where the person transferred to India pursuant to subsection 1 or subsection 2 is a prisoner in a contracting state, the court in India shall ensure that the conditions subject to which the prisoner is transferred to India are complied with, and such prisoner shall be kept in such custody subject to such conditions as the central government may direct in writing. Subclause capital C of section 105 deals with assistance in relation to orders of attachment or forfeiture of property. And subclause 1 says, where a court in India has reasonable grounds to believe that any property obtained by any person is derived or obtained directly or indirectly by such person from the commission of an offence, it may make an order of attachment or forfeiture of such property as it may deem fit under the provisions of section 105 capital D to 105 capital J, both inclusive. Subclause 2, where the court has made an order for attachment or forfeiture of any property under subsection 1 and such property is suspected to be in a contracting state, the court may issue a letter of request to a court or an authority in the contracting state for execution of such order. Subclause 3, where a letter of request is received by the central government from a court or an authority in a contracting state requesting attachment or forfeiture of the property in India, derived or obtained directly or indirectly by any person from the commission of an offence committed in that contracting state, the central government may forward such letter of request to the court as it thinks fit for execution in accordance with the provisions of section 105 capital D to 105 capital J, both inclusive, or as the case may be any other law for the timing in force. Section 105 capital D, identifying unlawfully acquired property. Subclause 1 says, the court shall, under subsection 1 or on receipt of a letter of a request under subsection 3 of section 105 capital C, direct any police officer not below the rank of sub-inspector of police to take all steps necessary for tracing and identifying such property. Subclause 2, the steps referred to in subsection 1 may include any inquiry, investigation or survey in respect of any person, place, property, assets, documents, books of account in any bank or public financial institution or any other relevant matters. Subclause 3, any inquiry, investigation or survey referred to in subsection 2 shall be carried out by an officer mentioned in subsection 1 in accordance with such directions issued by the said court in this behalf. Section 105 capital E, seizure or attachment of property. Subclause 1, where any officer conducting an inquiry or investigation under section 105 capital D has a reason to believe that any property in relation to which such inquiry or investigation is being conducted is likely to be concealed, transferred or dealt with any manner which will result in disposal of such property, he may make an order for seizing such property, and where it is not practicable to seize such property, he may make an order of attachment directing that such property shall not be transferred or otherwise dealt with except with the prior permission of the officer making such order, and a copy of such order shall be served on the person concerned. Subclause 2. Any order made under subsection 1 shall have no effect unless the same order is confirmed by an order of the said court within a period of 30 days from its being made. Section 105, capital F, management of property seized or forfeited under this chapter. And it says, subclause 1, the court may appoint the district magistrate of the area where the property is situated, or any other officer that may be nominated by the district magistrate to perform the functions of an administrator of such property. Subclause 2. The administrator appointed under subsection 1 shall receive and manage the property in relation to which the order has been made under subsection 1 of section 105 capital E or under section 105 capital H in such a manner and subject to such conditions as may be specified by the central government. Subclause 3. The administrator shall also take such measures as the central government may direct to dispose of the property which is forfeited to the central government. Section 105 capital G deals with notice of forfeiture of property, and subclause 1. If as a result of the inquiry, investigation or survey under section 105 capital D, the court has reason to believe that all or any of such properties are proceeds of crime, it may serve a notice upon such person hereinafter referred to as the person affected, calling upon him within a period of 30 days specified in the notice to indicate the source of income, earnings or asset out of which or by means of which he has acquired such property, the evidence on which he relies and other relevant information and particulars, and to show cause why all or any of such properties as the case may be should not be declared to be proceeds of crime and forfeited to the central government. Subclause 2. Where a notice under subsection 1 to any person specifies any property as being held on behalf of such person by any other person, a copy of the notice shall also be served upon such other person. Section 105 capital H, forfeiture of property in certain cases. Subclause 1. The court may, after considering the explanation, if any, to the show cause notice issued under section 105 capital G and the material available before it, and after giving to the person affected, and in a case where the person affected holds any property specified in notice through any other person, to such other person also a reasonable opportunity of being heard by order, record a finding whether all or any of the properties in question are proceeds of crime, provided that if the person affected, and in a case where the person affected holds any property specified in the notice through any other person, such other person also does not appear before the court or represent his case before it within a period of 30 days specified in the show cause notice, the court may proceed to record a finding under this subsection ex parte on basis of evidence available before it. Subclause 2. Where the court is satisfied that some of the properties referred to in the show cause notice are proceeds of crime, but it is not possible to identify specifically such properties, then it shall be lawful for the court to specify the properties which, to the best of its judgment, are proceeds of crime, and record a finding accordingly under subsection 1. Subsection 3, where the court records a finding under this section to the effect that any property is proceeds of crime, such property shall stand forfeited to the central government, free from all encumbrances. Subclause 4, where any share in a company stand forfeited to the central government under this section, then the company shall, notwithstanding anything contained in the Companies Act 1956 or the Articles of Association of the company, forthwith register the central government as the transferee of such shares. Section 105I, fine in lieu of forfeiture. Subclause 1 says, where the court makes a declaration that any property stands forfeited to the central government under section 105 capital H, and it is a case where the source of only a part of such property has been proved to the satisfaction of the court, it shall make an order giving an option to the person affected to pay in lieu of forfeiture a fine equal to the market value of such property. Subclause 2, before making an order imposing a fine under subsection 1, the person affected shall be given a reasonable opportunity of being heard. Subclause 3, where the person affected pays the fine due under subsection 1 within such time as may be allowed in that behalf, the court may, by order, revoke the declaration of forfeiture under section 105H, and thereupon such property shall stand released. Section 105J, certain transfers to be null and void. And it says, where after the making of an order under subsection 1 of section 105 capital E or the issue of the notice under section 105 capital G, any property referred to in the said order or notice is transferred by any mode whatsoever, such a transfer shall, for the purposes of the proceeding under this code, be ignored, and if such property is subsequently forfeited to the central government under section 105 capital H, then the transfer of such property shall be deemed to be null and void. Section 105K deals with procedure in respect of letter of request, and it says, every letter of request, summons or warrant received by the central government from, and every letter of request, summons or warrant to be transmitted to a contracting state under this chapter shall be transmitted to a contracting state, or as the case may be, sent to the concerned court in India in such form and in such manner as the central government may by notification specify in this behalf. Section 105 capital L, application of this chapter, and it says, the central government may by notification in the official gazette direct that the application of this chapter in relation to a contracting state with which reciprocal arrangements have been made shall be subject to such conditions, exceptions or qualifications as are specified in the said notification. With this now, we start dealing with chapter 37, namely last chapter as far as criminal procedure code is concerned. And these are miscellaneous provisions. There are some provisions to which we have referred to in the past. For example, trial before High Court. At the time when we started discussing trial before a court of session, I had also referred to trial before a court of session, and then section 474 says, when an offence is tried by High Court otherwise than under section 407, it shall in the trial of the offence observe the same procedure as a court of session would observe if it were trying the case. Section 475 deals with delivery to commanding officers of persons liable to be tried by court-martial. So section 475 deals with the same, whereas section 476 deals with forms, and it says, subject to the power conferred by section 227 of the Constitution, the forms set forth in the second schedule with such variation as the circumstances of the each case require may be used for respective purposes therein mentioned, and if used shall be sufficient. So this deals as far as the second schedule of with respect to the form is concerned. 477 deals with power of High Court to make rules, and it says every High Court may, with the permission of the approval of the state government, make the rules, and rest of the details are worked out. Section 478 power to alter functions allocated to executive magistrate in certain cases is dealt as far as section 478 is concerned, whereas section 479 deals cases in which a judge or magistrate is personally interested what should be done, and it says no judge or magistrate shall, except with the permission of the court to which an appeal lies from his court, try or commit for trial any case to or in which he is a party or personally interested, and no judge or magistrate shall hear an appeal from any judgment or order passed or made by itself. Explanation says a judge or magistrate shall not be deemed to be a party to or personally interested in any case by reason only that he is concerned therein in a public capacity, or by reason only that he has viewed the place in which an offence is alleged to have been committed, or any other place in which any other transaction material to such case is alleged to have occurred, and made an inquiry in connection with the case. 480 deals with practicing pleader not to sit as a magistrate in certain courts, and says no pleader who has practiced in the court of any magistrate shall sit as a magistrate in that court or in any court within the local jurisdiction of that court. Section 481 public servant concerned in sale not to purchase or bid for property, and says a public servant having any duty to perform in connection with the sale of any property under this code shall not purchase or bid for the property. And the section 482 deals with saving of inherent powers of High Court, and it says nothing in this code shall be deemed to limit or affect the inherent powers of High Court to make such orders as may be necessary to give effect to any order under this code, or to prevent abuse of the process of any court, or otherwise to secure the ends of justice. With this, section 433 duty of High Court to exercise continuous superintendence over the courts of judicial magistrate, and section 484 deals with repeal and savings as far as the criminal procedure code is concerned. With this now, we have come to the end of the criminal procedure code, and in the next lecture, which shall be the last lecture as far as our series of lectures is concerned, in which we will try to revise the part of the criminal procedure code with which you are dealt in brief, and then we proceed further.